Good evening, everyone, and welcome to another session with me, Deborah Bowers, on how to write a tax-efficient will. Today, we'll be looking at how property ownership can affect your will. And this is an area that I find has been coming up so many times, because whenever I take instructions from anyone to write their will, it's important that I determine how they hold property. And it's a complicated area, even for people who know, but for people who don't know, it is something that can be very mind-boggling. So tonight, I hope that we will unravel it together, and you shall leave here knowing exactly how to think about and how to assess how your property ownership is going to affect your will. I am Deborah Bowers. I'm a STEP certified advanced will writer. I'm also a solicitor of England and Wales. In my everyday practice, I practice as a GDPR practitioner. I'm certified on the GDPR practitioners course, also the CIPPE and CIPM. I'm also the author of this lovely book here, How to Write a Tax Efficient Will. This is a book which I wrote during the COVID period, when I found many people who were simply asking me about will writing, as we were going through a very stressful time during that period of COVID. And I thought, you know what, let me just put it in writing, because I can make it quite simple for them. And if they purchase the book, I will put examples in there which will assist them to write their own wills. I've tried to make it as simple as possible so that a child 10 years old can actually read it and understand it and would be able to carry out a will writing exercise. I do hope that it does deliver, because it became a #1 bestseller in its first edition. This edition is the second edition, which covers everything in the first edition, as well as lasting powers of attorney. The book is available on amazon.co.uk. So speaking with me tonight and having this discussion does not mean that I'm going to be providing you with legal advice or financial advice or investment advice. Neither does it mean that there's going to be a lawyer-client relationship between me and you. This is a discussion, and you'll be welcome at the end to ask me any questions you wish relating to wills, lasting powers of attorney, and I will answer them to the best of my knowledge and understanding, but I would always advise you to seek expert advice or verify what I have said. Trust but verify, which is something that has become very commonly used in the profession these days. You can trust but verify. So how can the way that you hold property affect you? How can you hold property in the United Kingdom? There are several ways that you can hold property here in the UK. You can be a sole owner of that property. You can also be holding it as a joint tenancy. So you hold in the property, there's someone else or other people involved, and you can hold property as tenants in common. And you can always also hold property as a trustee. So we shall be exploring each of these options as we go through this program tonight, because when you're writing your will, it's important that you are certain about how you hold the property that you have. So in this discussion tonight, we explore each of these, and I'll try to clarify how property is held and how you can apply that ownership as you write your will. Now, when you are the sole owner, you know, it's like being the commander-in-chief. You are your own boss. You are the captain of your own destiny, and you can distribute your property as you see fit. The power is in your hands because you own what we are speaking about. There's no one else in play. There's no bank, there's no loan. You're a sole owner. You know, there's just no one else. So you are your own boss, so to speak, when you own the property, if you are a sole owner. And as far as your will goes, you can distribute as you see fit. Some people, we have some situations where people leave all their property to a dog's home or a dog's trust. Yeah, they have every right to do that. It's their property. So they can do whatever they wish to do with it. Now, this second one, joint tenancy, very tricky. Just think of it as several people at the table. Here we can see at least 4 persons at the table. And they have ordered a meal and they appear to be sharing that meal, right? Now, what would happen if someone has to leave early and they have left the table and there's all that food on the table, it's a plate for sharing? The other people will simply be entitled to eat whatever is left there. So you won't be leaving some for the other person who's left, who's no longer at the table eating with you. And that's how to think about a joint tenancy. It's a platter for sharing. And if one person leaves, then it belongs to those who are left. So those who are left at the table that we just saw will eat the food that was available at the table. So this property in a joint tenancy is not subject to the wishes that you have in your will, simply because if one person leaves the table, the others who are left are the ones who are entitled to what is there. It passes under the right of survivorship. So there's a separate set of law to deal with these joint tenancies. So if, for example, you've got a house and you own it by joint tenancy, when one person dies, the other person automatically becomes the sole owner of the whole. So when you're investigating how you own property, you need to look at the documents to see, is it a joint tenancy or is it a tenancy in common? You need to know exactly how the property is held. And that is always in the deed. So you need to find the deed and understand how the parties own or hold that property. Because in this case, as we saw at the table, if one person leaves, tough, more food for me, so to speak. And so it was a joint tenancy. And it is governed by the survivor takes all. So you need to live as long as you can to outlive everybody, so you can get the whole. So if everyone leaves the table, the last person is actually entitled to have it all. So what type of property does this apply to? It applies to any kind of property. It could be land, it could be bank accounts, it could be houses, anything whatsoever. Property is property, and how you hold it is either going to be in one of those forms that we saw earlier. Sole ownership, joint tenancy, tenants in common, or you hold it as a trustee. And that applies to anything that is defined as property. Now, if you wish to say, no, I want my share, we saw that lovely platter earlier. And if a person actually wants their share, they don't want anybody else to have it. We saw that everyone at that table had a plate in front of them. So even though there was a spread and a platter of food that everyone could take from freely, everyone had a plate in front of them. So what you would do, you would take from the platter and put it in your plate. That would be indicating that, no, this is for me. It's the same principle here. If you wish that you do not wish to own property under the right of survivorship, the last man standing takes all, then you wish to either serve a notice of severance of that joint tenancy. And taking food from the platter and putting it into your plate actually indicates that. Most times, someone will not be taking the food out of your plate, which you've already been eating, even though the rest is left there. If you leave that there at the table, no, because you have severed the relationship between the platter, the spread, and your personal, what you want to treat as your own. So to sever the joint tenancy, you would have to serve a notice of severance of joint tenancy on the other persons who own that property with you. You can also agree by mutual consent. Okay, we sign a document by mutual consent. We are going to treat the property as not a joint tenancy anymore. It's a tenancy in common. Or you can demonstrate that the parties have always acted upon their share as if they were tenants in common. So yes, we own it as joint tenancy because that's the legal ownership, but we have always treated each as if, this is mine, like a house that a number of people have rented together, and each person has taken a room in the house and treated it. This is my space, my space, my space, my space. The house isn't one where anyone can go into anyone's room and enjoy the bed for the night as and when they please. It's not like that. So you can say in this situation, although they have rented the property together, but they have always treated the different sections of the house as if it belongs to a particular person. And in this case, it is treated as a tenancy in common because they have always acted as if everyone owns a room, no one can get into my room, please stay out. And this is treating the property as if it was a tenancy in common. So if you need to prove that, then you'd be able to show that you have the tenancy, the joint tenancy was always treated as a tenants in common. Also, an act of any of the joint tenants interested operating upon their own share. So we have a pizza, for example, and we're sharing, and I have taken the pizza cutter and I've cut off that quarter. It's 4 of us. I've cut off that quarter to show, look, this is mine. I've put it into my plate. And that would be an act by one of the joint tenants operating upon their share because it was an entire pizza at one point, and now it has become severed because I've taken that piece off and have placed it into my plate. So that would mean that, oh, this person does not mean that we should all be having this pizza together. They've cut it out to show which part belongs to them. So very interesting and a bit complicated, I understand. But if you are in a joint tenancy, you can sever it. And that's the most important thing here. But you must know that you are in a joint tenancy. And if you don't sever it, then it operates by the right of survivorship. So the person who lives the longest takes all. So the winner takes it all. And taking it all means you've got to outlive everyone else. So then you can't write in your will, I give my share to this person, because that would be irrelevant under the rules of joint tenancy. If you have not served, that is, a severance of the joint tenancy. So very complicated in its own right, but doable, so to speak. So we see this tenancy in common now. We shall move to that. And although we have a pizza demonstration here, it's like if this pizza was cut up in 4 pieces. In this case, just one piece of this pizza belongs to me and the rest belongs to someone else. Okay, so because we have a tenancy in common, that can be that I only hold, if this pizza was a 10/10, I own 1/10 and the other person owns the 9/10. So in this case, I could take my piece of pizza, my 1/10, and pass it to whoever I wish. It's mine. So I'm sole owner of this 1/10 of the pizza. And the other 9/10 goes to someone else, whoever owns it. So I can write in my will, I hereby devise and bequeath my 1/10 of a pizza to Jack Jones, because it is mine. So in a tenancy in common, you can actually pass whatever it is that you own to whoever you wish. There is no need to sever anything. It is already severed. In this case, we had a pizza. I own 1/10 of it. The 9/10 belongs to someone else. So I can only pass under my will the 1/10 that I own. So you see here, you can distribute what you own as you see fit. So I can pass it to my doggy. I can do other things with it. And you can pass it within your will, outside your will, before you pass, after you pass in your will. So you can pass it in your life. You can pass it after you've passed, in your death. The power is in your hands in relation to this one, because you are the sole owner, but of that little piece, not of the whole. And it's important that you recognize that you can't pass in your will the whole, which you do not own. You can only pass the tiny piece or the section, the percentage, the share that you own. So when we hold property as a trustee, when does that happen? Now, the most common way is when we have trust, when we've set up trust. So we see in trust, the beneficial ownership of the property is divided from the legal ownership. When I'm writing a will for people, I say, who do you wish to appoint as your executors and trustees? Yeah. What I'm doing here, I'm saying, who do you want to hold the property? Someone must hold the property. You've passed, so someone must hold the property as the legal owner. But who are they holding the property for? You're not giving it to them unless it's your children who have become the trustees, as well as the beneficial owners. You have these responsible persons holding the legal ownership for the benefit of whoever else you have appointed to give that gift. So for example, let's take an example. I write a will and I say, I appoint my brother Peter as my executor and trustee. And you have then to oversee the property in my will. But I bequeath all my property to my son, Jack. So I actually gave the property to Peter, but only to hold the legal estate because I'm no longer here. But if I give all my property to my son, Jack, then Peter is only holding it legally as the legal owner, but he's holding it for Jack, who is the beneficial owner. This is why after the will is probated, Peter now has to pass the legal ownership as well over to Jack if Jack is old enough to hold the property. Okay, so he has completed the probate of the will. He now has to pass the legal ownership from himself to the beneficial owner. So he holds it as trustee for a period of time so that he can take charge of making sure that everything has been done correctly. He knows where all my assets are. He has gone to the solicitors. He has gotten the will probated. And now his role is to distribute the gifts that I have awarded my beneficiaries to them. So he now has to pass whatever legal ownership he has to each beneficiary based on what gift was given to them. So although it sounds a bit complicated, that's one of the best ways to describe it, because the legal ownership is temporarily held by someone else who is called the trustee for the benefit of someone else. Another example is that I have a ring and I give it to my sister. I said, give this to my daughter, hold this for me and give it to my daughter. I have given her possession of the ring, but the ring is actually for my daughter. So when my daughter arrives, she has to hand it over to her. You know, so that's the way to think about it. a trustee, you hold property as a trustee, you have been entrusted to do something on behalf of someone else. So the role of a trustee usually arises under a will, and there is the legal ownership. It is given to the trustee, but the beneficial owner is the beneficiary. Sometimes the legal owner is also the beneficial owner. For example, if you appoint your children who are all 18 years and when you've passed and above, you've given them the legal ownership. You say, look, you need to take responsibility, probate this document, which is the will. And when you have done that, you pass the beneficial owner to yourself. So initially the ownership with them is the legal ownership. And when they have probated the document, then they pass the legal ownership to them. The legal and beneficial ownership comes together in them, which is called the vesting of the property to the beneficiaries. So again, very interesting, a bit complicated if you're not familiar with it, but this is how you think of it, because the property, although it appears to go to the trustees, it's never theirs, because they have to pass it to the beneficiary. Okay, so if you wish to learn more about this, and if you wish to work through writing your own will, I do have a course, How to Write a Tax Efficient Will. It's currently on discount at £48.50. And I do have a special gift for anyone who, the first 10 people to register on this course are entitled to a free gift. And that gift is going to be a copy of my book, a free copy of my book, How to Write a Tax Efficient Will. The course is available on Mastermind, and you can get the link and purchase the course, which is on discount right now. And just send me I will see that you have purchased, send me your details, and I shall be sure to post you a copy, a hard copy, or no, not a hard copy, but a copy, not an electronic copy, a copy of the book, How to Write a Tax Efficient Will. So all my details are available here. You can also visit my website, Deborah Bowers Will Writing. Visit my YouTube channel. Yes, please subscribe and share the link with your friends and family. There's just so much information there, which is all free, that can help people decide how best to write their wills, and just so much information to educate you, all free, at Deborah Bowers on YouTube. So share and subscribe. You can also contact me via email, deborahbowerswillwriting@gmail.com. Don't forget to secure your course. There's a free book with for everyone who secures their course for the first 10 people. And also you can call me on 079-818-10322. So if you've got any questions, feel free to unmute yourself if you need me to explain something again, and I'll be happy to answer your questions, queries, or concerns. Any questions? Yes, it's a paperback. It's a paperback. Thank you. The name just slips me. It's going to be a paperback. Yes, a free paperback for the first 10 people who sign up. Okay, then, well, there are no questions tonight. Thank you so much for attending. I really appreciate having you all here. I'm going to stop the recording, and we shall meet again next week. Please like and share. And I look forward to welcoming you again next week. Have a good evening.